Good afternoon, everyone. Thank you, as always, for joining me here on the ABA Division for Public Education Twitter stream. I am pleased to be joined, as always, by Professor Stephen D. Schwinn, the UIC John Marshall School of Law. Professor Schwinn, thank you once again.
Well, it's a pleasure to be with you again, Kathy.
Thank you. And today we are going to be talking about a case that will be heard right after the Thanksgiving holiday by the Supreme Court. We think Trump v. New York, also known as the census case. Professor Schwinn, can you tell us a little bit about how this case is before the court and what the justices are expected to hear?
Yeah. So there's a kind of short backstory and then a longer backstory. Let's start with the short backstory just to set up the immediate dispute. President Trump issued a memorandum this past summer that directed the Secretary of Commerce, which is in charge of the census count, directed the Secretary of Commerce to report two different sets of census numbers to the president when the secretary would report these numbers, scheduled at the end of December. One set of numbers would be the ordinary census count of everybody in the United States. The second set of numbers would be everybody in the United States minus unauthorized non-citizens who are here so-called illegally or without authorization. Now, the idea here then would be that President Trump, in determining the apportionment for congressional representation, would use that latter count, the total population minus unauthorized non-citizens, when President Trump certified those numbers to Congress. And then Congress, in turn, would apportion representatives based on a total count minus unauthorized non-citizens. The effect of this would mean that locations with large populations of unauthorized non-citizens would be underrepresented in the apportionment count and ultimately underrepresented in their seats in the House of Representatives. So that's kind of the short backstory. And the precise legal question there is whether the president can do that. Can the president issue a census count minus unauthorized non-citizens for apportionment purposes to Congress? The longer backstory, Kathy, begins back in 2018 when Secretary Ross went looking for a reason for including a citizenship question on the census questionnaire, and ultimately got the Department of Justice to say that they could use those numbers, citizenship numbers, to enforce the Voting Rights Act. That case went up to the Supreme Court in 2019, and the Supreme Court said, well, that doesn't make any sense. The secretary does not need these numbers to enforce the Voting Rights Act. That's a contrived explanation. And so we're not going to allow the secretary to put the citizenship question on the census questionnaire based on that reasoning alone. The ruling theoretically gave the secretary a chance to kind of come back and come up with a better explanation to do that. The secretary didn't do it. Instead, what we saw is President Trump issue this memo. And so in that way, the memo is kind of a backdoor way of getting around that earlier Supreme Court ruling and nevertheless getting the numbers that President Trump wanted of unauthorized non-citizens and excluding them from the apportionment count.
So Steve, who's bringing this case? I know it's Trump v. New York. So is it the state of New York? Is it the unauthorized citizens who or the unauthorized residents who is bringing this, and why is they important? And can we talk a little bit about standing here and why that may be where the court spends some time at argument?
Yeah, it's a fantastic question, Kathy, and a really important one in this case. So there are two groups of plaintiffs, kind of broadly speaking. Some states have brought a claim and some individuals have brought a claim. Now, in order to get into federal court, we need to show that a plaintiff has been harmed, right? And that they've suffered a kind of concrete, individualized harm to them. So the question is, what harm have the states suffered and what harm have these individuals suffered? Well, what the states say is, look, by counting in this way, excluding non-citizens, some states, particularly California, New York, are states leading the charge here, that they're going to lose representation in Congress because of large populations of unauthorized non-citizens in the states. And by the way, not only congressional apportionment, but also federal money. There are billions of dollars in federal funds that are tied to census numbers. And so to the extent that these numbers then are driving those federal funds, they also stand to lose federal money. Individuals are claiming that they're going to lose representation when non-citizens are counted. And they're also saying that this memo that Trump issued actually discourages individuals from filling out the census form because they think, well, look, if I'm not going to be counted anyway, why am I going to go to the trouble to reveal my identity to the federal government that might then move to deport me? And so there are these really two significant standing questions. Do the states have standing on this theory that they'll lose representation and money? Do the individuals have standing on this theory that they're discouraged from filling out the census form and will also lose representation in Congress? That's a really important threshold question in the case. And as you suggested, Kathy, I think a way that the court could dodge the underlying merits issue if it wanted to.
So let's say the court gets past standing and jumps into the merits. What do you anticipate being the bulk of the argument as to the actual merits here? What's the statutory history? What are the parties going to be arguing about?
Yeah, and so there are a couple of constitutional provisions that overlap with statutory provisions, the Census Act and the Apportionment Act, that are going to drive the arguments in the case. So the 14th Amendment says that the census counts all persons, right? And historically in our country, that has meant all persons. Every single census has counted unauthorized non-citizens in the census count. Every single census going all the way back to our founding. And the only exclusion to that in the Constitution has been slaves, which was in the original Constitution, but taken out in the 14th Amendment, and Indians not taxed. Those have been the only categorical exclusions. So again, the census has done this from the very beginning. The language seems to support it in both the Constitution and in the Census Act and the Apportionment Act. And so what the parties are wrangling about is whether the president has authority to deviate from that longstanding history within the text of the Constitution and the Census Act to determine that individuals that would ordinarily be counted don't really need to be counted for census purposes. What the Trump administration is arguing is, look, it just stands to reason that people ought to receive congressional representation in Congress, and states ought to be apportioned representation in Congress that reflects the individuals who are here with authorization, not unauthorized non-citizens. And moreover, that any federal money that might be tied to those numbers is also tied to people who are lawfully in the country. Opponents are saying, well, that's never been the way that it is. And we have folks who are labeled as unauthorized non-citizens who live in the country, but who nevertheless have been here for a very long time, have established deep roots and contribute meaningfully to the community. And they too ought to be represented in Congress. And so the debate is a textual one about the text of the Constitution and the Census Act, but really it got this kind of overlay of a long history and tradition of counting everybody in our country.
Oh, that's fabulous insight. Thank you. One sort of last issue before we end this chat on this case. What are the chances the court hears this? We've had a federal election since this was granted cert. It was a fast-tracked case, certainly. It was not on the court's calendar when they originally set this argument calendar. They added it in. The census has wrapped up, but we're waiting the numbers to be reported in January. And what are the chances? It's not the Trump administration, but a Biden administration that's getting these numbers. And what will the court do with that information that's happened recently?
Fantastic question. So the COVID-19 has set the census back, or potentially set the census back. And we've seen throughout this census process, throughout 2020, the Trump administration working in kind of fits and starts to, by one reckoning, accommodate the COVID-19 crisis, by another reckoning, just outright politicize the census. What it's been doing is first expanding deadlines for the census on the recognition that individual data collection is going to be harder to do in the COVID-19 crisis, but then rescinding those expansions and putting the census back on its original deadline schedule, which by the census's own reckoning was going to be very, very difficult, if not impossible, for them to meet. Now, what that meant was that Secretary Ross would deliver these numbers to the president by the end of the month. Then the president would deliver the numbers to Congress by January 10th. And of course, we have inauguration on January 20th. That looks now like that timeline is not going to be met, and COVID may be a contributing factor. Other things may be a contributing factor, but it looks like the Census Bureau is not going to be able to report its numbers to the president, and then the president report the apportionment to Congress by January 10th, and indeed even before January 20th. Which would mean, as you suggest, that then the next president, presumably President Biden, would be in charge of reporting the apportionment to Congress. If President Biden is in charge of certifying the apportionment to Congress, I think it's far less likely that we exclude unauthorized non-citizens from the apportionment count. Again, just because we've never done that. Not doing it seems to comport better with the language of the Constitution and the Census Act. All this means that the case might, as a practical matter, become moot if the census is not able to deliver those numbers in time to the White House, and if President Trump can't deliver them before January 20th to Congress. If this moves into the Biden administration, in other words, then I think this case probably is moot.
I think it'll be really interesting after how many years of a Trump administration entangled in legal challenges over the census. We end up with a Biden administration being the one to actually apportion the seats coming out of it in the federal funding. I think will be an interesting footnote in history books for generations to come.
Kathy, there's another deep irony here, and that is that the Trump administration in other contexts has been so successful at dragging its feet through litigation and winning by just sort of wearing out the opponents and running the clock. That seems to have been its strategy with the census as well, but it looks like it's going to backfire if the numbers can't be delivered in the Trump administration.
Well, Steve, we'll see what happens on the 30th and in the coming weeks after as well. And perhaps you and I can come back to this space and chat a little bit more about the challenge and the oral argument.
Thanks, Kathy.
Bye-bye.